Stand by while NCLA cuts through the noise to signal abuse of administrative power. This is Administrative Static with Mark Chenoweth and John Vecchione.
Welcome back to Administrative Static, and I think that the next couple of segments are going to be on, can law schools teach law anymore? We are going to take as our jump-off point the horrible events at Stanford Law School. I think just unbelievable, and certainly in the legal community and the legal profession, it's widely known. Judge Duncan of the Fifth Circuit was invited by a Federalist Society chapter, and the Federalist Society basically has chapters at all the law schools, and they invite speakers. And Mark has been a speaker. I've been speakers. You go to the various law schools and you give a talk on whatever subject, and they publicize it beforehand and put up flyers and say what you're going to talk about. So Judge Duncan is a appointee to the Fifth Circuit, which is Texas, Louisiana, and Mississippi. And he was going to talk on the Fifth Circuit's jurisprudence on COVID and guns. And he went to do this, and he was introduced by the president of the Federalist Society. And then all this heckling began. And there was tons and tons of hostile students at Stanford. And Stanford is one of the top schools in the country. And
folks can see this videotape, John. It's been posted online.
It has been. So two things have been posted. First, a videotape has been posted, but also an audio tape. David Latt, who is a longtime commentator and somebody whose opinion on these things I respect. He's not right wing or left wing. He's a law geek, is what he is. And so David Latt has gotten an audio tape, and he has a Substack, but he's also just put it on YouTube, I'm pretty sure. And you can go listen to this. And the judge came in, and he begins to give his talk, and he's being heckled by these folks who don't like his jurisprudence, don't like that he was appointed by President Trump, don't like the Fifth Circuit. And a lot of what seemed to be driving it was his views on his not even his views, his rulings on transgender issues and on abortion and things like this.
Use of pronouns.
That's the transgender issue. He basically did not. There was a child rapist who wanted to be called by female names, but the scam there was that the child rapist was trying to get into a woman's prison. And in any event, he cited laws where we use these words. This is how English works, that sort of thing. And in any event, but they're attacking him like his sexual preferences and stuff. It was not like, oh, that was you didn't do the logic tree properly, and nothing like that. And so this has caused a firestorm because it is really unbelievable. It is unbelievable that a judge gets asked there. And if it was just students, you'd think, well, now the administration comes down on them, right? No, they had a DEI, a diversity, equity, and inclusion administrator, which I now have seen from sources I believe, but I'm not an expert in this, that Stanford has the most DEI administrators in the country of any law school.
Interesting.
And this DEI administrator gets up there, and she lambasts the judge, but
so they could let one go and still have enough.
They could still have enough, but then she gets up there and she says, well, she talks all about their free speech policies at Stanford, then intimates that she disagrees with the free speech policies at Stanford, the written ones, evidently, because they're not going to be enforced, I have a feeling, and we'll be discussing this. But then she goes on and says, well, why are you here? Because your presence and what you're saying hurts people. So I mean, I was absolutely stunned as I looked at this because I'm like, that's the administrator they sent to meet with the federal judge. There was no professor there who wanted to talk to a federal judge. There was no lawyer there. Well, maybe she's a lawyer, but she's a DEI person. So how much of a lawyer can she be? But in any event, I was absolutely appalled as she says, and this will become fair. We will say this all the time. I saw Judge Duncan the other night at an event, and I almost said, was the juice worth the squeezing about what he was coming to, but I didn't have the guts. So I shied away from it.
You decided the juice wasn't worth the squeeze.
I did. But she says, was the juice worth the squeezing?
She said it over and over again.
Oh, yeah.
Just trying to get him to not give his speech, essentially.
Right, exactly. And he didn't. And what he did do is open up the floor to questions. And some of the questions went a little better than I thought they would go, but they were still hostile and people using that kind of accusatory illogic that if you come out the wrong way on an issue, that your arguments about standing hurt people, like just saying what the standing issues are. Now, we here, Mark and I, are always saying how the standing rules have to be changed. No one attacks standing rules more than me and Mark, but we don't think that when the judge comes out against us on standing, they have some sort of deep-seated prejudice. There are tons of cases on standing. You have to read them, and then you have to apply them to the facts, and then, the chips fall where they may.
And many of them are on completely non-controversial topics.
Correct. So this was an outrage. It was absolutely terrible. But why are we talking about it? Because in administrative law, particularly, but I think in most areas of law, we cannot have judges and lawyers who only care about outcomes. And I think Judge Duncan was asked, it's very interesting. First of all, he brought up Jacobson
versus
Massachusetts as a reason why he had not enjoined Texas's laws during COVID about
abortion, right?
No, it was all medical procedures.
Oh,
but abortion was included.
But that was the reason why people were upset.
Right, exactly. But they were upset because it had stopped all kinds of optional, the laws basically stopped optional medical procedures. So I think even emergency abortion, life-threatening, were still allowed, right? So it was all optional medical procedures. And the Texas legislature and the governor did that. He didn't do that, but he said under Jacobson, which is another case which we think has been overinterpreted, and Mark and I have attacked many times. He said, I think I was bound by it, which is completely reasonable. You know why? Because a bunch of judges in Massachusetts thought that, who were all appointed by Democrats, and a bunch of judges in the Seventh Circuit from both sides. A lot of people think that is just the case. And yet he's attacked because of who appointed him, and because he's come out the wrong way, and because he has an original syntextualist views. And in the law schools today, apparently it's allowed to make you, an enemy of humanity. The Latin, Scalia would always use it, generous, it's right now. But anyways, it was what they used for pirates and people like that who you could kill on sight. That was the law. It was enemies of humanity who the law didn't really apply to. And that's what's happened. And it's special.
And this is a presidentially appointed Senate confirmed federal judge that
Correct.
you're talking about here.
Who's very nice. He's very nice.
Guy. He's the former head of Beckett,
right.
Fund for Religious Liberty.
And they're all yelling at him because he got mad. Well, you're allowed to get mad when people are being rude to you. He didn't use profanity or anything, but I just
mild epithets.
Yeah, mild as very true in barnyard, I think is what we call it. But in any event, but the fact of the matter is that this is disturbing for the legal profession, because Stanford Law people, like Yale people, and we had a kid at Georgetown, William Spruance, who's just written about what happened there. And in that case, at Georgetown, a law professor who's been doing women's issues for 40 years, and I would think would be called the woman of the left, put on her law tests. She asked because it was gender law, she asked in the test to write, how would you support the hijab laws of France? And how would you oppose this other law? I think that was in Vermont or somewhere. I don't recall.
But make legal arguments on your exam.
Make legal arguments about gender laws in your exam. And students had gotten upset that this was somehow Islamophobia, and she was just absolutely vilified after 40 years working there for doing law problems, which always some law professors would always try to get the most crazy thing they could in the test or in the hypothetical, so that you would think that's what it's for.
So you would think. And John, lawyers are trained to be able to argue both sides of an issue. I mean, that's one of the things people don't like about lawyers sometimes is the fact that a lawyer could. I mean, I remember in high school debate, my parents would say you could argue, both sides of anything, and but that's part of what legal training is the ability to do that. And if we're now saying there are some topics where one side of the argument is completely forbidden and no one can take that side of the issue, then we've really lost sight of what legal training entails.
And the fact that all of the major law schools are coming out this way, although I have to say, I have not heard, I hate to say this, but I haven't heard all these stories coming out of Harvard. And I'm wondering why. We ought to look into that. But the fact is,
well, John Manning is the dean, and he's a conservative, so that may have something to do with it.
I did not know that.
Yeah.
So, but the point of it is for this, and we'll come back in the next segment. But because it's very important for where our judges come from, where our legal profession comes from, and the atmosphere in a legal profession. When it turns against having lawyers to be able to argue cases for clients who have constitutional rights, when you have expelled all these people from school, when you have not allowed them to talk, not allowed law review articles. These people are going to be the editors of law reviews, and they're not going to let certain ideas go back and forth in law reviews. Law reviews are very important for the formation of ideas in the law. And they're not as important as editors of law reviews think they are, but they are important. And so we'll be back in a minute. There's more to the story. So, Mark, why is this happening? And, I think a good factoid here is that the Dean Rosenberg, who's the dean of Stanford, wrote an apology letter, and she was on it with, I guess, the dean of students. And there's speculation that she's on it because she didn't trust the dean of students to really apologize in the letter. And so they sent it to Judge Duncan, and he said, well, you should apologize to the Federalist Society members who weren't able to hear the speech, because this is it. Free speech is also the listener. We say that all the time. But then she taught a course the next day. Now, no one disrupted her course because the rules are tighter for disrupting a course rather than an outside speaker, if you can believe it. And
that's interesting. So they can enforce it when they want to.
All these people at Stanford, they're all gunners. They're not gonna go against something that really causes them problems, right? All their pain can somehow be not voiced into a disruption when it will hurt their careers. And so, but what they did
that juice is not worth the squeeze.
Correct. And one thing they did do is they all dressed in black and protested her as she left the course that she did teach. And they did that because she'd written an apology for their horrible behavior. And now, why are they there? Why is this allowed? And the reason it's allowed, I was thinking about this, academia has always been pretty left-wing in my lifetime. But when they tried this in the 80s, they tried that
radical takeover,
ideological tendency, tried it, but they got pushback. They got pushback from the traditional liberals who were still there and the conservatives who were still there. And you really couldn't do that. I remember people would come up to me and say, oh, how can you say that? I said, well, what can they do to me? It's blind grading, right? I didn't, but you have to have a little, there were social pressures, but come on. I think that, but now as Judge Duncan said, the inmates are running the asylum in a lot of these places, and there isn't. We always thought, I certainly always thought, that this would never touch law schools, that this would burn out in colleges. There'd be in the social studies, in the social environment and I didn't think it would even get to the hard sciences, and now it's getting to the hard sciences. But the intellectual and moral vigor of the administration has been sapped. And I think it's been sapped by this DEI business that everything's oppression. No, sitting down and listening and then having a cogent argument and coming back. Robert's Rules of Order is not a tool of fascists. It's a tool of anti-fascists. And I think that the allowing these students to do this to anyone they disagree with, who are always going to be of the Judge Duncan ilk. At my own college, Angela Davis, who was got money from the Soviet Union, who was a vociferous, wanted to overturn our constitutional structure, has been lauded at all of these places. She can go talk anywhere. And her gun was used to kill a police officer. She was a person who wanted the Soviet Union to win the Cold War, which would have shut down all the lawyers. No, there's no real law there. And she is lauded. And she doesn't get shut down. And yet somebody who's a federal judge who believes in the rule of law and that words mean things, they don't mean other things, that is verboten. And Robert's Rule of Order is verboten. We can't have law that way. You cannot train students that way. You can't have moot court that way.
That's all true. And the thing that's particularly alarming to me about this, John, is one of the reasons that you have to have guests at these campuses to bring up these points is because there aren't any professors left on these campuses who espouse these views. So if the students are going to get exposed to these views, it's going to have to be at a Federalist Society meeting with an outside speaker, maybe a federal judge or a professor from another campus, maybe. And if you're not going to allow these folks to even come and express these views on the campus, then these sorry students are going to be blindsided when they go out into real life to practice, because they're going to find out that there are people out there, including people on the bench, who have these views.
And not only that they have these, but I say even more than that. I think there are professors, liberal professors on campus, who know the originalist and textualist arguments and know the arguments for social conservative well enough that they could participate in a moot court on the other side, but they won't, because they don't believe that their students can understand the idea that you're taking a role even more. I mean, I think it's even more scary than that, because I think some of those guys could do it, but they will not.
Right.
And so you do have to have the outset, but there's more. The other thing that I think that these students, not number one, I think they have to be disciplined. Once you punish this behavior in ways that hurt their careers, they will stop. They are not Joan of Arc out there. They're not going to, do anything to anoint the king. They are not that type of person. If they were that type of person, they wouldn't be so rude. Because I'll tell you this right now, people like Václav Havel and people who really had real oppression to fight didn't fight it this way. Martin Luther King. I mean, did you notice what they did? They had conversations. They went and they met the arguments to the other side, is what I noticed what they did. So, who did do this? The students in the 30s in Germany. They had a very strong view of how the world should be. The future belonged to them, and they ran professors out of those schools. And
especially Jewish professors.
That's true, but anyone who didn't buy, I mean, it was more widespread than that. Christian professors who didn't buy into the new order, let's put it that way. So I think but there's another thing going on here, and I think it's more subtle than that. Why have the textualism and originalism, which is a minority view amongst the big law and the law profession that we all work in, why are they so successful? And I'm going to say, as someone who joined the Federal Society in '86 and has been pushing on this for a long time, it's because steel sharpens steel. We can't go into any conference room or any courtroom or anything and assume that our arguments are going to be accepted because they're all socially acceptable by everybody in that room. We actually have to make arguments that become almost irrefutable. And we have to enter into places where we're minorities, and I mean intellectual minorities, and suffer hostile questioning and brutal questioning. if you come from an environment where you've been coddled the whole way, you're not going to be able to do that. If you come up against someone who has their whole life been an intellectual minority and had to assert these against a hostile crowd and a hostile intellectual environment, and you've gotten soft, you're going to be like Rocky and Rocky 2. And you've just been going around and everyone's been cheering you and you haven't been working hard, and you're going to get Clubber Lang's going to slaughter you. That's what's going to happen because he's been hungry his whole life. That's what's going to happen. That happens in intellectual pursuits as well. So the administrators who lack courage to sanction these kids are not doing them a favor. And I know, they're in their 20s. I'm sorry. I'm going to call them that because that's how they're behaving. And so that's what's going to happen. But even from a progressive, if I wanted the progressive viewpoint to prevail, I would not educate lawyers this way, because you would not be educating them to move the ball, in the direction of history. I'll use the capital H. You still are failing them, and you're failing them because they're not going to be as good as the person who had to take all the slings and arrows and hear every argument that could come up from people who believed it. And I will say the other thing that's interesting about this whole what's happening in education that hurts the law schools, which I didn't really realize, but I've been watching some comedians, and the comedians of about 5 years ago and 6 years ago, something like this, up till today, they used to go to college campuses all the time. And some of these law schools are on college campuses, and they used to go all the time. And that was a big venue, even when I was there. The comedians stopped going. So I think it's like one of these environmental videos. When you see one of these environmental videos that some animal stops going there, and then the whole culture, that's like the canary in the coal mine. Apparently the comedians were the canary in the coal mine. They didn't think they should go there. Everyone's too sensitive for their jokes. And so they stopped going to these schools. And now 5-6 years later, the federal judges can't go there. So it is almost like a toxicity that's growing up. And first it hurts, the most sensitive animal. And so what do you get at the end? That you just get the rats and the cockroaches. That's all that's going to be able to be in that environment. And I don't think that's an environment we want for the law.
It's not an environment we want for the law. I think toxicity is exactly the right word, and there's a dumbing down of the arguments as well, right? So even the folks who have views that are directly opposed to Judge Duncan, they're not having to make strong arguments on their side of the issue, because it's all just these wild assertions of you're evil and you're bad, and so well. There are good arguments on the other side of these issues, so learn them and make them. And that's what legal training should be about. And if you never have to do that because you're, as you say, John, you're coddled, or you're never exposed to these negative ideas, or when you are exposed to these negative ideas, you just throw out your shibboleths against them and never actually engage in reasoned argument, then I don't think you're going to win the day at the end. And I think that other people who are able to engage in these rational arguments are going to run circles around you.
And we see this, I think, on the Supreme Court. We see Kagan, right? Kagan went out of her way to learn this stuff. And she did it her whole life. She engaged her whole life. And now I would say for the progressives, she's the most dangerous, the person who turns through argument certain people's views and wins.
You mean Justice Kavanaugh?
I do, and Roberts,
Okay.
But in any event, so I think this is something that has to be watched. And no, I'm going to be stronger than that. If you are a progressive, there is an element of courage that's needed. And I think that if you're in a law school and you're a professor, and you could be as left-wing as you want to be, but this environment has got to be called out, and it's got to be stopped, and consequences have got to rain down. And just, isn't this sad, is not going to do it, because it's only going to get worse. And your institution will suffer. People will leave it. Even if you are Stanford, if you're turning out lawyers who are just table pounders who have whatever left-wing view and run to the next left-wing view, because really, you can't be safe. No matter how liberal you are, you're going to be attacked. So let's hope we don't hear too many more of these stories, but I'm not comfortable hearing any more of these stories. So I hope